Hi, this is The Business Guy. I'm the CEO of Lawyers Limited and Asset Protection Planners, the nation's largest asset protection firm. In this video, we'll examine the top 6 asset protection strategies, and you can follow these steps when creating your asset protection plan to help you understand your options. So no matter what is coming down the road toward you and your business, keep your assets where they should be with you. Legal risks are all around us. You can get into a car wreck where somebody sues you for more than the limits of your insurance policy. Somebody can falsely accuse you or one of your employees of sexual harassment, discrimination, or wrongful termination. In fact, we've had clients who were blindsided when a spouse suddenly announced that he or she wanted a divorce out of the blue. And speaking of that, what's blue and smells like paint? Blue paint. So to keep your assets so nobody can say you blew it, you need to know your options and to act early. And to do so, it is best to start asset protection planning now. If you've never created a plan before, though, it can seem like there are a lot of options. So where can you start? First of all, what is asset protection? Most people need an asset protection plan, but what is that? Investopedia's asset protection definition is the adoption of strategies for safeguarding one's wealth. And as part of a good financial plan, the goal of asset protection is to protect one's assets from creditor claims. Individuals and businesses use asset protection plans to limit the access creditors have to certain valuable assets. At the same time, it is important to act within the confines of debtor-creditor law. As a business owner, you can sleep better at night when you're lawsuit proof. And now I need your help. If you could please click the like button so YouTube promotes this video, I'd really appreciate it. And you can also click the subscribe button so that when more videos come out like this, you'll be up to date right away. As a legal measure, asset protection plans insulate assets while avoiding illegal practices such as concealment, contempt, fraudulent transfer, tax evasion, or bankruptcy fraud. Although anybody can create an asset protection plan, it is the preferable choice for those with significant assets to protect. Some common methods for asset protection include a domestic or offshore asset protection trust, domestic limited liability company, or an offshore LLC. Some assets are already exempt from creditors. Qualified retirement plans are protected from creditors under the United States federal bankruptcy and ERISA law. There are several states that do not protect IRAs or give very weak IRA protection, such as California. Many states do not protect Roth IRAs at all. These laws do not, however, protect retirement accounts from divorce. So for divorce, we need to employ additional measures. Some states also allow exemptions for a specified amount of home equity in a primary residence. Some protect personal property, such as clothing. Each state has laws to protect the owners of corporations and limited liability companies from liability within the entity. Now let's cover 6 general rules for protecting your assets from lawsuits. And what do you call a wave of lawsuits? A tsunami. Number 1, start planning before a claim occurs. The best asset protection security comes from starting early. Once you know that a lawsuit or judgment creditor is coming, it's too late for some, but not all, asset protection plans. Why? It's because each state has laws that protect judgment creditors against those who make asset transfers with the intent to hinder, delay, or defraud a creditor. The court will classify those late transfers as fraudulent transfers. Now don't worry, in this case we're generally talking about civil matters and not criminal ones. Now what happens when somebody transfers assets out of their name after somebody has started a claim against them? The court will likely order them to reverse the transfers and turn the assets over to pay the creditor. And that's why offshore asset protection plans work so well. Offshore trusts and your trustee/law firm can step in to protect you. They are outside of the local court's jurisdiction, so it does not matter if the courts order the assets to be returned. The trustee/law firm offshore will not comply. Since it is them and not you failing to comply, you typically get off scot-free. It's never too early to start protecting yourself from lawsuits. Starting your asset protection plan early helps ensure that you're protected when claims arise. Repositioning non-exempt assets as assets that are out of the reach of creditors' claims figuratively turns them into exempt assets. Rule number 2, create a multi-layered plan. Being fully protected against creditors and lawsuits means having multiple lines of defense. It isn't enough just to have a trust or LLC alone. As fine law explains, the best asset protection plans create a series of obstacles that any opponent has to clear. Now, of course, there are some plaintiffs that will have the stamina and strength to try to clear those hurdles, but the effectiveness of the plan comes from using the right legal tools. We have seen the combination of the offshore asset protection trust with the offshore LLC inside protect our clients' liquid assets every time. Naturally, the bank account needs to be in a bank that's beyond the reach of your local, friendly neighborhood judge. Now, we put real estate in the land trust for privacy of ownership. Then the real estate, other than your personal residence, will go into an LLC as the beneficiary of the trust for asset protection. Finally, we record liens against the real estate payable to an offshore entity to strip the equity. And then if needed, we get a third-party lender to purchase the liens, and the proceeds go into an untouchable account within your offshore trust. So when everything is set up properly, lawsuits run into a brick wall of protection at the end of all the hurdles. A proper asset protection plan can protect you no matter how deep the pockets of your opponent. You never know when a claim will arise, who it will come from, or what it will be about. And that's why it's important to create an asset protection plan that is ready to protect you against anyone. A plan that involves just trying to keep one step ahead of the creditors can ultimately fail. Rule number 3, make sure you understand it. Although your asset protection plan should have multiple layers, don't make it more complex than needed. If you can't explain how your asset protection plan works, then it isn't a good plan. That is why we have videos, attorneys, and consultants explaining how the entities work. When a deposition or debtor's examination comes up, failure to be able to clearly explain what happened and why makes the court suspicious. That alone could give the court grounds to start disregarding the entities or start setting aside transfers. There is a higher chance that the judge will find a case of fraud if they can't understand your asset protection plan. That's why it's so important to do it properly and have professional guidance. Rule number 4, get insurance, but don't rely on it. One line of defense in an asset protection plan is insurance. The problem is that when it comes time to make a claim, many insurance companies tuck tail and run. That is because they point to exceptions in the policy as to why they should not have to pay. Plus, no matter how much insurance you have, somebody can always sue you for more. Much more. Insurance can be a hurdle for a creditor to jump over or a catch-all system for anything the rest of your plan missed. So it's only a supplement to an asset protection plan, but you should not rely on it solely. Protective describes several different insurance plans to help keep your assets secure. Homeowners or business insurance, auto insurance, umbrella liability insurance, and life insurance. Rule number 5, use business entities. Now, one of the biggest mistakes an entrepreneur can make is lumping personal and business assets together. Blurring those worlds can leave you wide open to claims and cost you everything. An article in Money Crashers explores the best asset protection examples to create a separate business entity. Limited partnerships limit your liability. As a limited partner, you are not liable for any more than what you invested in the business. Lawyers would have a hard time coming after you personally to settle a claim. The downside to this entity is that you cannot take an active role in running the business. This is because you will be considered a general partner, and the general partner is fully liable to business lawsuits. That is, all the assets of a general partner are fair game. And that is why we make an LLC the general partner instead of a human being. Corporations provide great asset protection for their owners. Except in cases of extreme fraud, somebody cannot readily take your personal assets from you if your business loses a lawsuit. For tax purposes, there are two main types of for-profit corporations, the S corporation and the C corporation. Each have different restrictions and tax treatments, but both have similar lawsuit protection. Finally, limited liability companies. LLCs can provide some great asset protection with fewer ownership restrictions than S corporations. There is flexibility in filing for taxes as a sole proprietorship, partnership, C, or S corporation with an LLC. In some jurisdictions, LLCs have charging order protection. So even if a plaintiff latches onto your membership interest from a lawsuit, he cannot easily take your membership interest away from you. Plus, he can't force a distribution of cash. He does, however, still get taxed whether he receives the payment or not. This potential outcome can help you prevent a lawsuit or settle it with favorable terms. Two types of business entities that are best to avoid are sole proprietorships and general partnerships. Sole proprietorships have no limit on personal liability, so one mistake can cost you everything in the business and personally. General partnerships link all partners together in a dispute. If your partner creates a legal dispute, a lawyer could come after you and your assets as well. And finally, rule number 6, use an asset protection trust. Now, this is a big one, a powerful one. Can a trust protect assets from lawsuits? Now, there are a few trusts that can give you great asset protection. One type is a domestic asset protection trust, DAPT. However, these often fail because they are under the jurisdiction of a domestic court. The other is the Offshore Asset Protection Trust, OAPT. These are powerful trusts that benefit the trust beneficiaries. The primary goal of an asset protection trust, naturally, is to protect assets from creditors and to retain access to those assets. Laws vary by state and country, and a typical provision for this trust type is the grantor can be a discretionary beneficiary of the trust income and principal. That means you still have access to the money. At least one trustee must be located in the state or country of origin. Some of the administration must take place there as well. One might use this type of legal tool just for asset protection, or in addition to protecting assets from lawsuits, one can use it as part of an estate plan. That is, it will direct trust assets to another beneficiary when you and/or your spouse pass. The domestic version won't protect against every creditor. Depending on the state, some creditors may have access to such things as divorcing spouses and a child entitled to child support. Some will not protect from claims arising from injury, damage, or death that the grantor caused before transferring assets into the trust. That's where the Offshore Asset Protection Trust shines. The offshore trust is much stronger than the domestic counterpart. The strongest offshore trusts are in the Cook Islands, the Nevis Trust, and the Belize Trust. That is because the Offshore Asset Protection Trust puts assets beyond the reach of your local court. The local judge says turn over the money. In the Cook Islands, for example, our foreign trustee law firm says, sorry, you don't have jurisdiction here. An alternative to the Asset Protection Trust is a third-party spendthrift trust. This client establishes this trust for the benefit of another individual. Trustee discretion is an important benefit of this type of trust. The trustee decides how to control and distribute the money. There is also a provision that prevents a beneficiary from assigning or pledging their interest in future trust assets. An independent or corporate trustee may provide even better protection with this type of trust. The problem with this type of trust is that you lose access to the money. This trust protects assets by giving them away to somebody else. So this is not a viable option for most people. So the most powerful asset protection tool is the offshore trust situated in the Cook Islands in the South Pacific, the Caribbean island of Nevis, or in the Central American English-speaking country of Belize. We set up trusts in all three regions. So fill out our free consultation form on our webpage or utilize our telephone number to get more information. Get the protection you need. It's seldom too early to start creating an asset protection plan. Even if you've already started planning, there could be more that you can do to protect yourself. Ensure your plan gives you the best protection by contacting our asset protection attorneys and consultants today. We'll do our best to ensure that your asset protection plan does what it needs to help you protect what's yours. Please click like, subscribe, and share this video with others. See you next time. This is The Business Guy.